Hi everyone, thank you so much for attending my talk today. My name is Amna Batool and I'm a PhD candidate at the School of Information, University of Michigan. And today I'll be presenting my paper between court orders and platform policies. But before I start, I want to give a trigger content warning that I'll be talking about violence against women in this talk. So please feel free to take a break and leave the room if you feel the need to do so. I want to start with the harsh reality of Pakistan, where honor killing is a persistent form of gender-based violence. Those of you who don't know what honor killing is, it's mean killing someone, usually a woman, to restore family's reputation and honor. In 2024 alone, around 350 women were killed in the name of honor in Pakistan. And here we need to be mindful of the fact that only 2% of these cases are being reported according to various gender-based violence reports. Now, what's more alarming is that social media platforms are increasingly implicating to these killings. As you can see in these media news, that women are being killed mainly because of having a social media presence or because someone leaked their seemingly innocent images online. For example, a woman was murdered by her male relatives over the disclosure of an edited image showing her sitting next to her boyfriend even though they both are fully clothed. In another case, a mother and her two daughters were killed by the husband over the disclosure of their fully clothed video enjoying in the rain went viral on their family WhatsApp group. Now, these cases raise an important question that why do the disclosure of such benign content lead to such tragic outcomes? And the answer lies in the cultural context. In this case, the cultural context of Pakistan, which is deeply rooted in patriarchal and honor-driven norms, and where even innocent images and videos can be perceived as threat to a family's reputation. And if you look at the existing terminologies of image-based abuse, they do not effectively address the disclosure-related harms in non-Western contexts like Pakistan. Therefore, to bridge this gap, I identify a particular subset which I call non-consensual image disclosure abuse, or NCIDA, which is a new classification of online abuse that better captures the disclosure-related harms that have been overlooked in existing classifications. Examples include not in intimate imagery, sexual annotations, and insinuation through screenshots, as you can see here in red. To further understand the manifestation of NCIDA, I encourage you to read my prior work on expanding the concept of non-consensual image disclosure abuse, which is a case study in Pakistan. And for the sake of this presentation, I'll talk about the governance aspect of NCIDA, both from platform and law enforcement agencies' perspective, with an overarching goal of how do social media platforms and local legal frameworks interact to address NCID. And to answer this question, I collaborated with the cybercrime wing of a federal investigation agency in Pakistan. That wing was established in 2016 under Pakistan Electronic Crime Prevention Act, commonly known as PICA. And as a law enforcement agency, the role of cybercrime wing is to conduct investigation on all matters that come under PICA. So I conducted a discourse analysis of 68 legal requests submitted by cybercrime wing officers to Meta platforms to get access to perpetrators' account details reported by victims. In addition, I conducted semi-structured interviews with investigation officers and attorneys to understand the context and details of those requests. So based on this methodology, I examined the governance through three key aspects. The first one is the workflow between cybercrime wing and Meta. The second one is how Meta responded to those legal requests. And the third one is factors that shaped Meta's decision making. So let's start with the interaction workflow, and here's how the process actually works. So my data shows that when victims report a crime, their preferred remedy, especially in Pakistan, is to identify the perpetrator. And why do they want to identify the perpetrator? Is to settle the matter with them by having them delete all the content from all the devices, write a written apology, and cite a written assurance that there will be no future disclosure. As you can see in this flowchart, when victims report a crime, law enforcement officers conduct their due diligence on the request, and then they reach out to platforms through a designated portal in order, and from platform I mean Meta in this case, through a designated portal in order to request suspect anonymous account information, including IP logs and contact details, in order to identify, track, and arrest the perpetrators. And to operate within legal boundaries, officers submit a court order which holds the authority of law in Pakistan along with these requests. Platforms, however, conduct their own due diligence on the request, and they respond positively only if the request and the content involved in the request align with their data sharing policies. Otherwise, they reject the request even if the court order is attached. Now, regarding platform responses to legal requests, I found that platforms were relatively proactive in terms of responding to law enforcement agencies' requests, in contrast to much of the literature that criticizes platforms for delayed responses to user reporting. As you can see here, the majority of requests were answered within 1 or 2 days. However, proactive responses does not mean positive resolution of the request, as these responses usually include acceptance, rejections, or asking for additional information. And I found that despite this proactiveness, a significant percentage of requests were rejected by the platform, which led me to analyze the factors behind this decision making. And I found that the nature of the content involved in the request played a major role in platform's decision making. As you can see in this chart, most accepted requests involved sexually explicit content, indicating that platform prioritized this type of content as sensitive. In contrast, the majority of rejected requests involve non-explicit but culturally sensitive material, such as semi-nude or societal defamation cases, suggesting that platforms see it as less problematic. Now, let's review a couple of examples to see the content of these requests. For example, in case of a sexually explicit content request, officers requested detail of an anonymous Instagram account that is exploiting young girls by manipulating them into sharing their nudes. In a non-explicit but culturally sensitive content request, officers requested details of an anonymous Facebook account that is circulating girls' objectionable images among her family and friends, damaging her family's reputation. In a societal defamation content request, officers asked for the details of an unknown Facebook account that is sending abusive messages to a girl's in-laws, convincing them to divorce her. So now in all these requests, except the one that involves sexually explicit content, all the other requests were rejected, even though they were submitted with the court orders. And a typical response from platform when they reject the request is that there is no MLET or mutual legal assistance treaty signed between the governments, which is preventing them from sharing this information. Just so that you know, mutual legal assistance treaty are agreements between governments for sharing data in criminal cases. They facilitate intergovernmental cooperation, but they do not apply to private and global organizations like Meta, especially when both the victims and perpetrators are from the same jurisdiction. So platforms use absence of an MLET as a reason to these rejections, but officers perceive these rejections differently. According to them, platforms base their decisions on their understanding of harm, which is also reflected in their content moderation policies. As one officer highlighted, unless it involves nudity, platforms won't take it seriously. However, the officers try their best to help platforms understand that how the disclosure of non-explicit content can also lead to severe consequences. For example, as mentioned in this case, an officer tried to explain that the disclosure here could lead to divorce, and in Pakistan, divorce can easily result in physical violence for bringing in shame for the family. However, platforms did not understand this, so they refused the request while requesting for the evidence of physical harm, but there cannot be any tangible evidence for potential physical harm. Thus, according to officers, there is no point in reaching out to platforms after receiving an MLET-based rejections, and instead they rely on their own social engineering tactics to catch the perpetrator, which can or cannot be effective. However, exceptions are always there. As I've seen instances in my data where platforms had to comply with law enforcement agencies without an MLET, and that happens when local courts exercise their authority. For example, an attorney we interviewed mentioned a case where a victim filed a lawsuit against Facebook when they refused to provide data despite the court orders. The judge ordered a ban on Facebook as it was a clear violation of Pakistani law to refuse the court order, and the platforms remained banned for 10 to 12 days until Facebook took notice and sent an Asian representative to negotiate and establish some bylaws. This shows that local courts and local laws have the ultimate authority, and they can compel platforms to address non-consensual image disclosure abuse. So overall, my findings unpack various forms of misalignments between information sharing expectations of law enforcement agencies and information sharing practices of social media platforms like Meta. And I've shared some of those here, and we'll discuss the first one given the time constraint only. So my findings show that while platforms appear proactive, they only respond positive to requests they consider sensitive, and that aligns with their data sharing with their content moderation policies. Now let's keep sexually explicit content aside for a moment because platforms consistently or most often recognize this as a harmful content. But when it comes to non-explicit content, there are clear inconsistencies in how platforms assess harms. For example, in one non-explicit case, when a victim was accused of being lesbian, the platforms provided the data, possibly because they understand the sensitivity associated with the sexuality of an individual as reflected in their content moderation policies. But in another non-explicit case, where victims was accused of being a prostitute, the platforms rejected the request. This could either be because of platforms' inability to understand culture-specific harms associated with these labels, or it could be intentional approach to promote Western values aligning with the concept of digital colonialism. But overall, these misalignments lead to inconsistent handling of requests, which results in persistent confusion in decision-making, thus impacting the overall governance of non-consensual image disclosure abuse. So this concludes my finding, and I've provided various recommendations, policy and technological recommendations for the key stakeholders that are involved in the process. For example, platforms should focus on decoupling their interaction with law enforcement agencies from user-setting content moderation policies, and at the same time, invest in creating regional guidelines for users given the global reach that they have. Similarly, government should collaborate with platforms to create alternate compliance frameworks in the absence of these treaties and to create more comprehensive request submission template systems. And I'm happy to talk about these recommendations offline. This concludes my presentation, and I'm happy to take any answers from the audience. Thank you.